Hello everyone, I am Taniya Pandey and you're watching Courts This Week on LiveLaw. Let's look at the significant court updates of the week gone by, starting with the Supreme Court. The Supreme Court has held that the High Court, while dismissing or disposing of the quashing petition under Section 482 CRPC or under Article 226 of the Constitution of India, shall not pass an order of not to arrest or no coercive steps either during the investigation or till the investigation is completed or till the final report or charge sheet is filed under Section 173 CRPC. The bench of Justices D.Y. Chandrachud, M.R. Shah and Sanjeev Khanna observed that when the investigation is in progress and the facts are hazy and the entire evidence or material is not before the High Court, it should restrain itself from passing the interim order of not to arrest or no coercive steps should be adopted, and the accused should be relegated to apply for anticipatory bail under Section 438 CRPC before the competent court. The court also issued guidelines explaining when and where the High Court would be justified in passing an interim order, either staying the further investigation in the FIR or complaint, or interim order in the nature of no coercive steps or not to arrest the accused. The Supreme Court has observed that defense on merits is not to be considered at the stage of framing of charge or at the stage of discharge application. At the stage of framing of the charge or considering the discharge application, a mini-trial is not permissible, the bench of Justices D.Y. Chandrachud and M.R. Shah has said. In this case, the special court, considering the material on record, which included the transcript of conversation recorded between the complainant and the accused, and considering the other material on record, found that there is a prima facie case made out. The court added that the defense of the accused is not to be considered at this stage and framed the charge against the accused for the offence under Section 7 of the Prevention of Corruption Act. The Rajasthan High Court, allowing a revision petition, discharged the accused of the alleged offence. The Supreme Court, quashing the order of the High Court, noted that while discharging the accused, the High Court had gone into the merits of the case and had considered whether, on the basis of the material on record, the accused was likely to be convicted or not, when at this stage it was impermissible to consider the discharge application or framing of the charge. The Supreme Court has reiterated that an authority's interpretation of its own tender cannot be second-guessed by a court unless it is arbitrary, perverse, or malafide. In this case, a bid submitted by the appellant was accepted and a contract was awarded. The High Court, while allowing the writ petition filed by the bidder, set aside the award. The judgment was challenged before the Apex Court in appeal. The Supreme Court noted that the authority which floats the contract or tender and has authored the tender documents is the best judge of how the documents have to be interpreted. If two interpretations are possible, then the interpretation of the author must be accepted. In a notable judgment, the Supreme Court has held that a breath analyzer test or blood test, as contemplated under the Motor Vehicles Act, is not necessary for an insurer to repudiate an accident policy claim on the ground of drunken driving. The court held that if the insurance company is able to establish from the facts that the driver was under the influence of alcohol at the time of the accident, it will not be deprived of its right to exclude the policy benefit merely on the ground that the scientific tests for alcohol presence were not carried out. The Supreme Court has granted relief to former Andhra Pradesh High Court Judge Justice V. Ishwaraya against an order of the Andhra Pradesh High Court directing for a judicial inquiry into an alleged phone conversation between him and a district judge plotting conspiracy against the High Court Chief Justice and a sitting Supreme Court judge. The Supreme Court noted that the High Court ordered the inquiry against Ishwaraya while hearing an unconnected PIL related to following of COVID-19 protocols in the High Court. The Supreme Court has held that the 2019 amendment to Section 31 of the Insolvency and Bankruptcy Code has retrospective operation. Section 31 of the Code deals with approval of resolution plan. The bench of Justices R.F. Nariman, B.R. Gavai and Rishikesh Roy observed that the amendment is clarificatory and declaratory in nature and therefore will be effective from the date on which the code came into effect. The Supreme Court has recently observed that the state has an affirmative obligation to facilitate access to education at all levels. The bench of Justices D.Y. Chandrachud and M.R. Shah was considering writ petitions by two students for directing to facilitate them to be admitted respectively to the Lady Hardinge Medical College, Delhi and Maulana Azad Medical College, Delhi in terms of the policy and guidelines issued by the Government of India, Ministry of Health and Family Welfare through its Office Memorandum dated 9th April 2020 on allocation of Ladakh Central Pool seats in MBBS or BDS courses for 2020 to 21. The court directed that the admission process in respect of these two writ petitioners be confirmed within 1 week, with a view to obviate the hardship of moving the Supreme Court. The bench also directed that the other 7 candidates selected and nominated for the Central Pool medical seats be also granted admissions to the concerned institutions, if not already given so far. The Supreme Court has held that entries in balance sheets can amount to acknowledgment of debt for the purpose of extending limitation under Section 18 of the Limitation Act. In holding so, the bench of Justices R.F. Nariman, B.R. Gavai and Rishikesh Roy set aside a judgment of the full bench of the National Company Law Appellate Tribunal in the case of V. Padmakumar versus Stressed Asset Stabilization Fund, which had held otherwise. A Constitution bench of the Supreme Court on 16th April issued a set of directions to expedite the trial of cheque dishonour cases under Section 138 of the Negotiable Instruments Act. The order was passed by a bench comprising of Chief Justice of India S.A. Bogde and Justices L. Nageshwar Rao, B.R. Gavai, A.S. Bopanna and S. Ravindra Bhatt. On March 10th, the bench had formed a committee of experts headed by former Bombay High Court Judge Justice R.C. Chavan to suggest steps to expedite trial in cheque dishonour cases. The court directed the High Courts and the appellate courts to immediately send the appeals or revisions for mediation. During the hearing, the bench had also observed prima facie that the central government has the obligation to create additional courts to ease the burden created on the judicial system by the Negotiable Instruments Act as per the mandate of Article 247 of the Constitution. The court also directed that magistrates have to record reasons before converting trial of complaints under Section 138 of Negotiable Instruments Act from summary trial to summons trial, in exercise of power under the second proviso to Section 143 of the Act. The bench also recommended an amendment empowering the magistrate to recall summons in respect of complaints under Section 138 of the Negotiable Instruments Act. It was observed that Section 258 of the Code of Criminal Procedure is not applicable to complaints under Section 138 of the Negotiable Instruments Act, and the magistrates are not empowered to discharge the accused if the complainant is compensated to the satisfaction of the court. Let us now go over the High Court judgments. The Calcutta High Court was recently called to decide whether a court can appoint an arbitrator different to the one who has passed the award challenged when the award debtor and the award holder both desired it. Justice Moshami Bhattacharya, after holding that the arbitral award under challenge was liable to be set aside, drew from the emphasis of the Arbitration and Conciliation Act upon the autonomy of the parties to find that a different arbitrator could be appointed. The Kerala High Court was recently faced with an interesting question of law when deciding appeals against a Motor Accidents Claims Tribunal order on whether the tribunal could reduce the compensation payable on a motorcycle accident if the deceased pillion rider rode without a helmet. The tribunal had reduced the quantum of compensation, citing that the deceased, who was riding pillion, was not wearing a helmet. Applying the principle of contributory negligence, the tribunal modified the compensation. Before the High Court, the question was whether the principle of contributory negligence could be applied to such cases. The High Court held that simply because there is a violation of Section 129 of the Motor Vehicles Act 1988 by a victim in an accident, there is no presumption that there is contributory negligence on the part of the person who was not wearing the helmet. The Bombay High Court has taken suo motu cognizance of the surge in COVID-19 cases in various prisons across Maharashtra based on newspaper reports. 198 prison inmates tested positive in 47 prisons across the state as of April 14, 2021, according to the reports. Additionally, 86 staff members have also tested positive. The division bench of Justices Nitin Jamdar and Chandrakant Bhadang has directed the state to provide information on the status of these COVID-19 cases among staff and prison inmates, the measures taken and proposed to be taken to control the spread of the virus in the prisons, and measures to decongest jails. The Jharkhand High Court on 17th April granted bail to RJD President Lalu Prasad in Dumka Treasury case of the multi-crore rupees fodder scam, paving way for his release from jail. The bail was allowed by Justice Aparesh Kumar Singh. The court directed Prasad neither to leave the country without permission nor to change his address and mobile number during the bail period. The Manipur High Court on 15th April declared as null and void the election of Congress leader Okram Henry Singh as a member of State Assembly, Wangkhe Assembly Constituency, in 11th Manipur Legislative Assembly after observing that failure to disclose name of the spouse and his dependents, details of pending criminal cases, and educational qualification would constitute a corrupt practice falling within the meaning of undue influences under Section 123 Clause 2 of Representation of the People's Act 1951. Those were the top stories from last week. I hope you're staying safe and taking good care of yourselves. I'm Taniya Pandey. Thank you for watching. Have a wonderful day.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.